Back and we're going to start I think our walkthrough first with Eric Fitzpatrick from Ledge Council on H21, an act relating to service of writs of possession.
Thank you.
Welcome.
Thank you very much. Good afternoon, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, as the chair said, here to give a walkthrough of H21. There's an act relating to service of writs of possession. Just I assume everybody has a copy of the bill, either in paper or on their computers. But before we actually look at the language of the bill, just wanted to give a minute or two of background to sort of let everybody know what the area of law is that you're looking at here and what the amendment proposes to do. So what we're talking about here is service of process in a legal proceeding, right? Right. So it's the meat and potatoes, right, of one of the things this committee deals with. But it's an interesting term, service of process. What does that really mean? It really means sort of a different way to say service of legal papers in a legal proceeding. So, in a criminal proceeding, it could be you're serving a summons on the criminal defendant. Could be you're serving a summons on a witness. Could be in a civil proceeding, you're serving a complaint on somebody who's going to get sued. It could, again, also could be a witness who's being served with a summons in that situation too. But it's basically service of legal papers. Now, who usually does that? There's a variety of answers to that question, but most often, sheriffs and constables are the ones who serve legal process for purposes of legal proceedings. And the Vermont statutes give statewide jurisdiction, generally speaking, to sheriffs and constables to do that sort of thing. But statutes in particular subject areas will often have individual sorts of rules, particular rules for how service has to be done with respect to that particular type of court proceeding, with respect to that particular type of paper. And that's what we're looking at here. We're looking at a particular type of court proceeding that's referred to as ejectment, right? Now that has to do with property, and an ejectment action is basically when the claim is that one person is unlawfully occupying property or land that the landowner or somebody else is claiming, right? So they are claiming, look, my land is being unlawfully occupied by this other person. So they can bring an ejectment proceeding, which, as you might guess from what it's called, is a legal proceeding to try and get the court to order that person to get off the land and give possession back to the person who's claiming to be the rightful lawful owner. Does that make sense so far? All right. So this ejectment proceeding is actually one example where there are specific requirements for what the process has to look like. When I say process, it's interesting. I just realized when I said it out loud, well, it's true for both. What I meant by process, the papers that have to be served, although it's also true that the process has its own process too, speaking more generally of what a process is. Before I go down that side, a little side point, again, getting back to the service of process and sort of unique particulars for this ejectment proceeding. For example, it's interesting that the complaint, for example, when you serve a complaint in an ejectment proceeding, right? This is when the person claiming to be the rightful holder or owner of the land says, I'm going to bring this ejectment action and I want the complaint served on the person they think is in unlawful possession of it. Well, the complaint, there are some specifics about what the complaint has to say, that may issue as a summons requiring the defendant to appear and answer to the complaint. And the complaint has to state that the defendant is in possession of the land which the tenant holds unlawfully. Right? This isn't in the bill. I'm just kind of giving you a little background. So it's this whole point I made. This is a claim of unlawful occupancy of the land. If there's a rental agreement, it has to be part of the complaint. It has to be attached to the complaint. The statute specifically provides for that. So these specifics have to do with ejectment proceedings in particular. And if you sort of think about that, most often when you see them, it's a landlord bringing an action for ejectment against a tenant. For example, in the statute, there's a specific statute on this particular type for non-payment of rent, for example. That might be possibly the most common example of an ejectment proceeding, but it's not the only one. You might, we've seen them where, for example, two adjoining property owners dispute some land in the backyard. Somebody puts a tool shed on one part of the land. One owner thinks that's my land. They want to get ordered that to be removed. They could bring an ejectment proceeding. So any unlawful claim that land is being occupied unlawful is an ejectment proceeding. Could be an ejectment proceeding anyway. So, all right. Imagine then that the ejectment proceeding is brought. The person who is saying, "Hey, that person's on my property unlawfully," is successful. They can ask the court to issue what's known as a writ of possession, right? And that writ of possession is something that, again, is a court process, a court paper that will order the other person to, "Hey, get off my land," right? The court has found that you're in unlawful possession. You must now vacate. I want to put myself, the property owner, who the court has found to be the rightful property owner, into possession. So that's a writ of possession that can be served in these actions. And that's what we're talking about. That transitions us into H21, because that's what we're talking about, writs of possession. You've gone through an ejectment proceeding. You've got an order from the court saying, "I'm entitled to this property. There's someone unlawfully in it," whether it's a tenant who hasn't paid rent or someone who built their tool shed on my land, whatever it may be. And let's look for a moment at the language at one of these specifics about writs of possession and their service. And you'll see that in line 17, well, starting in line 17 anyway. It says, "The writ shall direct the sheriff of the county in which the property or a portion thereeof is located." See that? That's the specific thing that this bill is talking about, because the way statute reads now, the only law enforcement officer, a sheriff, who can serve the writ of possession is the sheriff of the county in which the property or a portion thereof is located. See? So there's a restriction on who can serve it in this particular case. Not, as I say, there's different requirements for different types of legal actions, but that is one for writ of possession. So
I think I was just going to clarify that can be different depending on the statute or law. Like,
exactly.
it's not for writs, like it has to be that. It just happens to be that's what it is.
Exactly right.
Okay.
Exactly right.
What makes it have to be a sheriff from Vermont? Doesn't say Vermont, it just says county.
In this particular, I think generally speaking, if you look at the overall service chapter, I think it generally applies to Vermont LEOs.
Could we simplify this by just on page or on line 18, changing direct the sheriff of the county if you change the to any county, and then you just struck all of the rest of the language till to serve. So it would just read, "The writ shall direct the sheriff of any county to serve the writ on the defendant not earlier than 14 days to serve," to put the plaintiff in possession.
Yeah, I think that would work too. Yep.
My thought being, why, if we're making a policy decision that there's no relevance to where the property is located, why keep language in there about the property at all?
Yeah, I think it works either way. So yeah, total policy decision for you guys.
Unless, and this would be my question, other question, was there a reason why before it was critical to maintain that only the sheriff that was within the county that the property was located fully or partially was the only sheriff that could be used?
I'm guessing.
This statute long predates my existence, not only in this job, but probably at all.
Yeah.
So,
Yeah,
so
I imagine
I
it's-
can look into, it is an old statute, but I
Yeah.
can see if there's any cases on that.
Okay.
And- or your witnesses, like Representative Burdick was saying, probably have better information than I do on that.
Yeah, cool.
But you segued nicely into what the proposed difference is, right?
Yep.
That's the proposed amendment, is to move away from that limitation on requiring that service of the writ only be by the sheriff of the county where the property is located, and instead permit any sheriff to serve a writ of possession after the court has issued it. So it's pretty straightforward, and that's the proposal.
Other questions for Eric?
Are there other types of legal process where other types of service processors can be used to serve process, like a constable or a agent?
Well, constables are in the statute, it says sheriffs or constables, not in this one, but the general processor, it says sheriffs or constables can serve process throughout the state. So
So did the language here preclude a constable from being an agent of service for this type of process?
interesting question. Read literally,
Yeah.
I would say yes. I don't know whether that's the practice or not, because of the general statute that says sheriffs and constables can serve process, are authorized to serve process statewide. Be interesting to hear in practice whether that has ever come up.
Okay.
Yep. That's actually a question leading to another comment, but escapes me.
Are there other types of process?
Oh, that's what it was. Exactly. Yes. So there is another statute that allows the court to appoint. I think it's called a disinterested person, something of that nature. So the disinterested person, it's relatively narrow, but the court can appoint a disinterested person, person without any interest in the underlying case to serve process.
And then this would preclude the court from doing that as well.
Possibly, but not necessarily. One could read, if there's a separate statute that says the court can, does it say always? I don't know. I'll look at the language. Maybe the statute might say it could be read to apply as a qualification to all other service or process statutes, maybe if it was enacted later in time, for example. I don't know that off the top of my head.
Okay.
Interesting question of statutory interpretation.
Yeah. Okay, that's all my questions. Sorry, Tom.
No, you're fine. Any other questions? Thank you, Eric.
Yeah, sure thing. Happy to help. Let me know if you have any other questions. Got to run to another committee, but anything else comes up, please let me know.
I lost my agenda. There it is. Amber Tebow.
Good afternoon, folks.
Hello.
Can you hear me? Just want to make sure.
Yes, just identify yourself for the record and have at it.
Absolutely. So good afternoon. My name is Amber Tebow and I'm an attorney with Bauer Gravel Farnham. Thank you for taking the time to hear testimony on H21. For a decade plus, I've represented landlords. As the committee is aware, since COVID, the number of complaints filed with the court for evictions has risen substantially. In our firm, the predominant number of those complaints are related to failure to pay. Landlords attempt to work with tenants for months before they seek representation and the ultimate result of evicting the tenant. Therefore, when the complaint is filed, the landlord seeks an efficient process to legally regain possession of that unit, which is done through the execution of the writ of possession. As proposed in H21, the modification to the language in 12 VSA 4854 will enable, but not require, the landlord to have the writ of possession served by any sheriff, not necessarily the sheriff in the county in which the property is located. This modification will assist landlords in situations such as the following. So you have a writ of possession that's served on the tenant January 30th. The landlord's entitled to regain possession on the 14th of February. After numerous email correspondence with the sheriff's department, a lockout date of the 18th is provided, but with no time. On the morning of the lockout, when attempting to confirm the time for the lockout, I'm informed by the sheriff that this no longer can occur on the 18th due to short staffing holidays, but is now on the 20th, almost a week after the landlord is legally allowed to regain possession of the unit. Execution of writs outside the 7 or 14-day window happen routinely in one county, which delays the legal possession of the unit, harming the landlord and potentially the unit. Second situation, properties in Winooski, but one of the tenants is incarcerated in Newport. Plain reading of the statute requires any writ of possession to be served by Chittenden because this is where the property is located. But in practicality, it makes more sense for Orleans to serve the writ on the incarcerated individual. As there is additional cost to hire a sheriff in another county to serve and execute a writ of possession, this will only be used when it is more efficient, but landlords would appreciate the ability to work with another county to enable them to regain possession of the unit in a timely manner. Thank you for your time, and I'm happy to answer any questions.
Any questions? I don't see any. Thank you.
Thank you.
Angela, is it Zykowski?
Here.
I don't.
No, if she's marked as invited, I invited her.
Oh, so, okay, so invited. Dan Gamelin, Sheriff Chittenden County.
Here.
Yep.
Thanks for having me.
Yeah, if you can identify yourself on
Hi,
the
I'm
record and,
Dan Gamlin, I'm the sheriff of Chittenden County.
Okay.
I've been at Chittenden County for 43 years. I've been sheriff for the last 2. I've done, I would say, thousands of evictions in my career, especially in the core of Burlington area. Amber, what I was going to say is Amber's already testified about it, is we've had papers that were from Bennington County to serve at Chittenden Regional Correctional Center on a writ of possession. So somebody's under eviction down in Bennington. The tenant is incarcerated. The order says to the sheriff of the county. Bennington County is not going to drive 3 hours to serve the writ. And this is some of the issues we have. We would serve it. We would notify the attorney that the serving this document is not really legal. We're not going to enforce it. And I don't even know if Bennington would enforce it. But that's one of the issues we're having. As she testified about somebody in Winooski being up in Northeast Correctional Center. It's the same thing. Another issue is Georgia does not have a post office. 50% of Georgia's mailing address is Milton. We get documents to serve in Georgia, right? But they're actually, it comes to us because it's a Milton mailing address. So we have an eviction in Georgia. If we serve the summons, complaint, everything up to the writ of possession, it's the Franklin County Sheriff that has to execute that and serve it. We cannot do it. So that's another issue that we've had up in Chittenden County. So.
makes sense. Karen?
So just curious, sounds like you would support this.
I
Then.
would support it.
And do you see any capacity issues or any concerns? Like, how would it navigate? Like, if you get one, you would just do it, or would it be
Well-
a choosing thing?
It would have to go to, for an example, I'll use Franklin County. If it was sent to Franklin County and they can't do it, the attorney has an alternative to come to us. I am not going to go to Franklin County and serve evictions. I got enough in Chittenden County to do that. Franklin County is not in my area to go start evicting people. That's Franklin County's issue. But if an attorney has an issue and they're not getting the paperwork served and or they can't execute the order, I can't do it unless something has changed.
Okay, you all set, Karen?
Yeah, no,
Yeah.
just to clarify that, it wouldn't be your general practice to it. You would want to wait and see, like, did you try to use
Yeah,
the
that's correct.
the current county sheriff? If that didn't work, but I guess it would be up to each sheriff's department to create what their policy was.
That's correct.
Okay.
Yeah, I have no interest in going to Franklin County to enforce eviction orders unless they can't do it.
And you charge mileage for serving writs.
It's 70 cents a mile.
So if, so there's also like a financial incentive for, if there was like an attorney trying to serve somebody in a county and they were having an issue with that county, the sheriff in that county, reaching out to a sheriff of another county, one of the things they'd have to be thinking about is paying the additional mileage
Right,
to have
correct.
them drive. Yeah.
Yeah.
Okay.
Anybody else? I'm guessing you know this guy.
I do very well.
Well, great. Thank you very much.
You're welcome.
Appreciate it. Okay, Sheriff Mark Anderson is up next.
Good afternoon. Mr. Chair, members of the committee, my name is Mark Anderson. I'm the Sheriff of Windham County and the President of the Vermont Sheriff's Association. Thank you for having me today as part of this bill. As I mentioned before the hearing started, I've been working on this for many months before this bill was even a bill. So what I would say, and all the stakeholders I've talked to, it's not that we have agreement on the destination of where the car's going. We struggle with the road to get there. So it's a typical Vermont road. You can't get there from here sometimes, but hopefully we can get there from here on this one. You've already heard from some of the people we've talked to, basically what we're trying to do. So I'm going to skip over that and start with the Yogi Berra quote, which is, in theory, there's no difference between theory and practice. In practice, there is. So the concerns I've raised with this is the unintended consequences. Always the concern in the legislature, not going to surprise anyone saying that, but what are the unintended consequences? So where this started for me was in House Government Operations last year, when there was a constituent in one of the counties who was issued the writ of possession and wanted it served, and the sheriff of that county said, no. I'm not going to get into why. I don't know firsthand the details of why, but it was basically no. And so then what? First answer is, and I'm going to go in a little more depth because we talk about this in House Gov Ops a lot, but we don't really talk about the structure of the sheriff's departments and judiciary. The sheriff is an elected official for the county. There's the high bailiff, which most committees in the state, the partisan committees in the state will laugh about in the party meetings of what does the high bailiff do. I used to be a high bailiff, so I can at least tell you with some credibility what it is. The high bailiff is responsible for serving all writs that the sheriff is incapable or incompetent of serving. And so my response to the representative with the issue was, call your high bailiff. And I will help your high bailiff through this process to serve a writ of possession. Representative Oliver, may I borrow your bill? This is what serving a writ of possession looks like. You need to read this. You have rights for it. Please follow the court process. Failure to do so could actually cause you to have trouble. I can't give you legal advice. Certainly encourage you to contact an attorney if you need to. But at the end of the day, please read the document. I'm happy to read it to you if you need assistance with that. Would you like me to read it to you? Thank you. That's serving a writ of possession. Seems very simple. It's like delivering the mail. We can water it down that easily. That's the theory. Thank you. That's the theory side of it. And so I come to a story. The story I have is that a constable from one of my towns was serving the entire series of documents for an ejectment. That's the complaint. That's filing escrow with the court. There's about 4 to 5 different consecutive orders that needed to be served over the period of about 6 months. Ultimately got to the writ of possession and served the writ of possession. My office, who also has a law enforcement contract in this town, receives a 911 call saying there's this old man at my house trying to break in. We respond for serious concerns to find the constable saying, what are you doing? And the constable told us, I'm doing an eviction. Now, number one, we know that this law says you can't do that. Number two, what we learned is that all the process leading up to that ejectment or that eviction was actually done wrong because we found all the documents that he, quote unquote, served under a rock on the porch, never handed to what would be the defendant in the civil case. Handing the paper to the person, making sure we're handing it to the person. There's so much that ties into this where we contact legal counsel all the time to determine, have we done this correctly or not? There is resolution for the landlord in this case, which is he could file suit against the constable for providing improper service, for causing the landlord all this grief up until then. But most landlords don't want to go through the additional process. They're frustrated already when they have a person who's not paying rent for 3 months, 4 months, 6 months, 12 months, 2 years, to say, I have to start another civil action. So what do we do? And so as we look at this issue, we're saying, how do we help landlords who have gone through the process? It is a cumbersome process, right or wrong. I'm not here to lay issue with that. How do we help the landlord when they've finally done the things that they were supposed to do and now it's in our court? How do we make sure that the person received the defendant received their full legal rights, they received proper service that the court will uphold, and not what we call sewer service? And so we've talked with the high bailiff of that county. We've talked with the advisory rules committee for the judiciary. We've talked with the joint legislative rules committee. Talked with senators and representatives, and now we are here today to speak about this and to say, we don't want this to be something that the landlord is having to shuffle the process as the plaintiff in this. but we also don't want to break the practice. So as it reads right now, it says that the sheriff of the county is responsible for doing this. What happens when they don't? Good reasons or bad reasons. They don't have staff. They said, I just don't want to. We do have laws that address that. One is a criminal law, which is called neglect of duty. And so there have been sheriffs in the past who've been charged with neglect of duty for failing to perform their duties as required. We have in Title 24, we have the duties of the high bailiff who can serve writs that the sheriff is incapable of doing so. So we do have solutions to this already. But could we do something better? And so that's where I come to this bill. In Title 24, there is a section under Section 312 that says the powers of the sheriff with respect to criminal matters and the enforcement of the law may be exercised statewide. So that's where we get our statewide criminal law enforcement authority. Doesn't apply to civil. 24 VSA 293 says that the sheriff shall execute lawful writs, warrants, and I could continue on, but do the things. Title 12, so this is court procedure. Section 691 says sheriffs and constables may serve either civil or criminal process anywhere within the state and returnable to any court. And so our first thought was, we already have laws that deal with this. And talking with some of the stakeholders, the attorneys, landlords, they said, yeah, but when we get down to the section that this bill addresses, it kind of dials us in more specifically. And so we feel we need to fix this.
What was the site?
Yes.
What was the site for 12 VSA?
The first one was 12 VSA 691.
Yep. And then the other one was there wasn't a second 12 VSAs. There were two 24 VSAs.
There was a 24 VSA 312.
Yep.
There's 24 VSA 293.
Yep.
And I haven't gotten into it yet, but now 12 VSA 696, which
State 691. That's the one that's saying it can be outside of the county.
691 is sheriffs and constables may serve either civil or criminal process anywhere within the state and returnable to any court. So there's already the authority to do this. And so what we're not looking to do is upset the process. So if the sheriff in Bennington receives the writ of possession for a property in Bennington and realizes the person is incarcerated at Chittenden, it makes more sense to have the sheriff of Chittenden serve the papers. But the sheriff of Bennington is also responsible for ensuring everything that leads up to that process has been done correctly. If it was served under the rock, not to the person's hand, not through an alternative service ordered by the court, that's improper service. So that person was never afforded their right to due process. When my department received that 911 call, the landlord said, well, you're the sheriff, you serve it. And I said, I already know that this entire process has been invalidated and everything leading up to this process has been invalidated. I'm sorry. I'm the messenger on this one of you paid for junk service. And that sucks for me, having to go to this individual who's gone through the process and say, you wasted your money. I'm sorry, start over. But I was the messenger. And what that landlord ultimately did was gave the tenant who had been living in their apartment for months without rent, gave them money and said, just move out. That's not our civil process work or civil system working correctly. That's not how it should work. The landlord did what they were supposed to do. The system failed them. So coming to this section, what I would suggest as an alternative pathway to the language that's in the existing bill, and similar to what you were asking about, is there a way to make this simpler? The idea being we have logical reasons why another sheriff should do this. In the case of a sheriff saying, I will not do this, not my problem, I don't care, I am just being completely against any of my responsibilities, like the far extreme of I don't want to. Well, another sheriff could come and say, I'm going to go do those things. It's not going to be every day that happens. Could it happen? No, sure. So if we deal with that extreme of things, we could have another sheriff say, for this one case, we're going to come to a neighboring county, we're going to serve the papers. Currently, on all forms of civil process other than writs of possession, sheriffs already do this. But the process doesn't break in that it was directed to the sheriff of that county. And then when that failed, then we worked it out amongst ourselves to make the process continue working. So you always know where the documents go and the pipeline is followed. If we change this to say any sheriff in the state of Vermont can do this, we never know where it's going to land. And so it could very quickly become, well, we sent the notice to the Chittenden County Sheriff to evict a person from Brattleboro. Does it make sense? No, but it could happen. You've heard testimony today that the cost would be more expensive. Title 32 actually sets out the fees that sheriffs charge. It's set by statute. We don't charge an hourly fee or anything. If it takes me 3 attempts to serve a piece of process, I get paid the same as if I serve it once. So it's better for me to be effective and successful in getting the person the papers on the first try than to go 3 times. People who don't want to be evicted from their properties for whatever reasons often will avoid service. So it makes it already more costly. And then we're compelled by federal law to pay an hourly wage to our employees. So my costs continue regardless of whether or not I get mileage, whether or not I get this fee on the single service versus 3 services. My costs are still building. The administration of this to make sure that the courts are getting the returns of service, the attorneys are getting the paperwork that they need, all the steps that go with it. This is ongoing overhead, which if I'm the sheriff in Windham County getting compelled to go to Orleans County, that's a problem. Or if I'm going to the Brattleboro retreat where they will not acknowledge or confirm or deny whether a person is a patient there under protection of federal law, then I'm sitting here trying to knock on the door to say, well, we did our best and federal law is protecting them with the privacy rights. So the language that we would suggest is leave the statute intact. And then notwithstanding, and I'm not an attorney, so obviously this could be dressed up, but notwithstanding, nothing in this section shall prevent a sheriff of another county from serving or executing a writ of possession in the county. I think it does the same thing as the language that you have, but I think what it still does is preserves the accountability measures for a sheriff who says, I'm not going to do it. Unfortunately, I've had to deal with that. I don't like to deal with that. I would like sheriffs to just do their job. It's not a common problem, but this isn't the first time that the Sheriff's Association has had to talk about this. So to solve the problem, I think that that would be a way that we can say we're taking the monkey off of the landlord's back who's currently paying for it. We're taking the monkey off the attorney's back who's representing the landlord to get this service performed. And we're providing a continuity of service outside of what already exists through the high bailiff or other statutes. But at the same time, we leave the accountability with the county sheriff in that area.
Can you repeat your proposed language?
I can. Either notwithstanding, I wrote nothing. Nothing in this section shall prevent a sheriff of another county from serving or executing a writ of possession in any county, which mirrors the language in Title 24 for the most part, and then 10 of the other statutes.
So your proposed language would still allow me, if I was a landlord in Brattleboro and I wanted to evict somebody, to go to the Chittenden County Sheriff and ask them to do.
It would allow it, and it would make sense if they're in Chittenden Correctional Facility. Because I don't want to drive to Chittenden Correctional Facility or pay one of my deputies the 6 hours to drive there and back to say, here you go, and here's your flat rate.
And so there's just something about the way that having it in the same sentence as it is right now, you don't like.
What we don't like is by saying that any sheriff is responsible for it, becomes all 14 sheriffs are responsible for it. So there's no longer a responsible entity. Some of the work the Sheriff's Association did in past bienniums was around sheriff's accountability. So this has been a third rail that I've touched too many times. And that's why trying to preserve the accountability piece is important.
And then my only other question is, for compliance with 12 VSA 696.
Yes.
Who is responsible for ensuring that the sheriff receives all writs that are served within their precincts? So if I do that circumstance, let's say my tenant isn't in Chittenden Correctional Facility and that tenant is actually in Brattleboro, and I do go to the Chittenden County Sheriff and have them serve it. Is it my responsibility to give it to you as well, or is it the Chittenden County Sheriff's responsibility?
An interesting question. I'm not sure I know the answer exactly. The way the general process or the practice works is that it is the plaintiff or their attorney who's going to provide it to the sheriff for service. We have had issues where orders have been issued to the wrong court. I'm sorry, to the wrong sheriff. So Windham and Windsor counties often get confused. And so we'll receive orders in Windham County for Windsor County,
Yeah.
which is a simple, you mailed it to the wrong place, here you go. Well, if it becomes the confusion factor of, hey, we got a Windsor County order, but it came to Windham and any sheriff can do this, at what point do I just start doing it? So it can start to create some other complicating issues just because people had a basic typo. But I'm not sure I know the answer, who's responsible under that specific section.
Okay.
For instance, I learned early on that it was a good thing to have your sheriff, start with the beginning serve, ride that whole thing all the way out. As opposed to have a constable serve something in the middle or whatever, if you didn't know it was done right or not. Now, we could theoretically have the same problem here, like I receive a writ that needs to be executed. I don't know if that other sheriff who's the problem did anything correct. I guess, so is that a concern?
It is a concern. So another unique issue with sheriffs is that under Title 24, the sheriff is personally liable for the actions of the sheriff or their deputy. You will find that in no other law enforcement entity in the state of Vermont. So why do I care? Because I can personally be sued. My house can be taken. That's a scary concept when you start talking about, are we doing it right or are we doing it wrong? And so in the situation of the 911 call and the constable who had improper service, even though the landlord did the things that they were supposed to do and the service was wrong, had we said, nope, we're giving you the writ of possession and you need to leave, that tenant could file suit and get returned back into the apartment, could get all of the money that my insurance can cover, and then any damages that the court wanted to award if they were successful in their suit.
The process is, as far as the constable goes, that a sheriff would give it to the constable?
The constable really had nothing to do with this other than they were unlawfully serving the writ of possession.
Would they get it? The writ? Who would give it to them to serve?
In that case, it was an attorney said, we want you to serve this because we feel that this section of Title 24 gives you the authority. Our argument has always been this section of Title 12 that you have before you says the constable actually can't do that. And it turns out constables have no training on this. They generally don't solicit legal counsel. They don't have insurance. So yeah, the client or the person would have the same ability or course of action to file suit, but the constable has far less means for that civil liability. So they could say, the defendant's filing suit against the constable for inappropriate actions. Court awards damages and there's no insurance policy. There's no significant means of resources that they can be sued for. And so what happens? Kind of the same thing we see on other civil actions, which is, hey, the court agrees with you and you're getting $0 out of it. See you later. So I don't like having the liability, but at the same time, the sheriff is bonded. By statute, we're bonded for inappropriate actions. We carry insurance policies for inappropriate actions. And those are generally not found with constables, or the constables protected by the League of Cities and Towns if the town has their insurance.
I was gonna assume most of the time it's probably a deputy that's gonna be serving the brother. Most of the time.
It's a mix statewide. I've certainly served my fair share of these. I do have a deputy who does a lot of these as well. There's some sheriffs who do all of it themselves. There's some sheriffs, I think Chittenden is actually an example where they have a dedicated process server because of the sheer volume.
So you guys go through some kind of training, I'm assuming,
We do a lot of training.
and hold, the sheriff's doing it for one thing, but the deputy's doing it. Or you're holding your deputies accountable. But then with the constables, I think you said, as far as you know, that they're not going through any training and there's nobody to hold them accountable.
So the constables are an interesting construct, and I'm not here to
No, I'm not looking.
diminish constables or talk about the constables, but just as a point, constables can be either elected or appointed. If they're elected, they're an independently elected official who then operates under the authority granted to them under the Constitution and statute. The sheriff's authority has certainly been formulated over the last 200 plus years, far different than the constables have. And so there's a lot of things that have been built over the structure of the sheriffs that weren't as much built for the constables in the process serving world. Sheriffs have a history that go back to kings in London. And so this comes from ties and the shires, which the name sheriff comes from, the shire's reeve, the reeve being the person responsible for all the people. And so all these things started to come from English law, which have ultimately been carried over to the United States. So some of these are ancient structures that are just what they are. And so those cultures, those traditions, some of the case law has carried forward just from way before any of our time. But with that, with an elected constable, and VLCT might be a good witness if you want to talk about constabulary liability. Elected constables have presented liability issues to a lot of towns, and I've seen them testify and share with towns their concerns with constables. Appointed constables, appointed by their town select board, does fall under the jurisdiction of the select board. VLCT could also talk about what are appropriate policies that a town should adopt. They recently came to one of my towns in Windham County where they recommended, I think, of something like 97 policies. And they said, this is too much work. We're going to contract with the sheriff. So there's a lot of liability in law enforcement. There's a lot of liability in civil process service. The Sheriff's Association has attorneys on retainer to be able to give advice on request. As opposed to delays through the Attorney General's office when we say, could you review this? We need to seize the airplane that's on the runway right now. And we say, or we hear back, it might be 6 weeks.
From the AG.
From the AG. So from our attorney, it's give me 5 minutes, hold the airplane. Thank you, I can do that. But we want to know if we're seizing something, taking someone's constitutional right for lawful or unlawful seizure of property without due process. And I'm the one carrying the lawsuit if we're wrong. So we really care to get it right.
So if you agreed, before agreeing to do something out of county, the execute a writ or whatever, it would be a wise move to avoid a heartburn, to maybe reach out to the attorney that's handled the previous service, as well as maybe the sheriff that's not doing it, and get the history and the service process, maybe.
Yeah, I think a sheriff would do their due diligence to understand why this service isn't being accomplished. Sheriff Gamlin just shared in his testimony how he would feel uncomfortable and or feel it's unlawful to execute, serve, or even enforce a Bennington County writ of possession under current law. In the same context, in the same context, if we were to change, if you were to change the statute and we were to enforce the action under the statute, I still carry the same liability. So I want to do all of my homework to make sure all the I's are dotted, all the T's are crossed.
Just to clarify with the new language, it doesn't necessarily change anything, like it's the same, but what I'm getting is that it gives cover kind of to the expectation that your local county person should do it first.
Yes.
And then it creates that expectation of it, and then others can fill in if they choose to, based on the circumstances and their desire to risk liability or whatever that is.
Yes.
Okay. And then I'm also, I don't know what I'm hearing actually on this part about if we add a constable or court-appointed disinterested person. Do you have any input on that?
I would discourage it.
Yeah.
We've talked to the Civil Rules Committee and others. So other states have introduced it, and the term that comes up is what's called sewer service, which why it's called that, because as I understand it, it's because it's as good as throwing the piece of paper in the sewer, and that's going to be the service. That's what other states have experienced with it, with what I'm referring to a sewer service, which is basically people wash away the intricacies of civil law, saying all I'm doing is handing a piece of paper to someone, you've been served, ha ha ha, not understanding that we have layers and layers of statutes, sometimes conflicting statutes in civil law, that we are trying to transact. And because the service of process is fee-based, there's a financial motivation for a person to say, I'm just serving this and I get my money. So as long as they get their money, they're done. And so when things go sideways 6 months later, it then becomes a, I'm distancing myself from this issue. I have no dog in this fight. I did everything I was supposed to do in proper service, which is not accurate, but that's what's being said. So that's the hard part with disinterested third parties, and other states have had difficulties with that. There are provisions under judicial rules, and I believe this is a question, and certainly don't take this as nothing more than a lay understanding, but judicial rules does allow the court to appoint certain individuals. One of the things that we raised in our testimony to the Rules Committee was how do we determine the qualifications and that person has adequate liability protections were a defendant or a plaintiff to pursue the process server in a civil action. Doesn't happen often, but often that's also even a disparity because the civil process, the civil court process often is paid for by the plaintiff. So if you don't have the money to pay an attorney, you're just not going to get the same service as if you do.
I think that's helpful.
Sheriff Gamblin, you concur?
So the language says on line 17 and 18, the writ shall direct the sheriff. So is the writ of possession, the document itself say in it, like the sheriff of Windham County shall serve?
Yes.
So would that prohibit someone from using a sheriff of another county unless they went back to the court to have the writ changed?
Under current statute, the court is directed to issue it to the sheriff of the county. So generally speaking, unlike an arrest warrant that says to any law enforcement officer in the state of Vermont, a writ of possession is directed to the sheriff of that county. So there, if the statute were to change in some way, I don't think there'd be a need to do that. I think that would just be working with the court administrator's office to say, how do we reframe the template to do the thing that they need it to do without adding additional process for attorneys or plaintiffs to be able to pursue?
Yeah, but the language would say the writ has to direct only the sheriff of the county where the property is, right? So it would we need to change the language here to say that the writ shall, like, you see what I'm saying? Like, I get that your amended language would allow someone to do the service with another sheriff, but if the court is complying with the statutory language, they would need to say the writ is directed to the sheriff of the county.
So I don't think it would change the fact that the writ is still directed to the sheriff of the county.
Oh.
It's when the sheriff of the county has a lack of action for some reason.
And does a sheriff, and maybe that's where I'm misunderstanding. So if a sheriff of another county can exercise a writ, that writ is directed to the sheriff of a different county?
I'll go to other civil documents. I mean, we have writs of replevin, writs of execution, writs of attachment, all of them.
Oh, yeah.
So with the other statutes I quoted, generally a sheriff of another county can go serve civil process statewide.
Yeah.
The issue, and we've been advised by our legal counsel, is that even though it does say that, they still encourage me, the sheriff of Windham County, to get deputized in Chittenden County to go serve Chittenden County civil process, not because the law explicitly requires it, it just starts to get a little gray. So to your point, might there be some additional tweaks? Maybe. The reason why we didn't want the statute to be directed to any sheriff is just because it then just becomes this open, who's responsible for it now, which then becomes the problem of, well, 14 of us are responsible. And so where do we play hot potato now on the one that nobody wants to serve for a reason I can't even think of right now, but just plain devil's advocate.
Yeah, no, and I see your point and I see where your language makes a lot of sense. I'm just wondering if there's a way that we can tweak it so that we're ensuring that you're not in that weird place where you're feeling like you have to get, because that seems sort of defeat the purpose as well that we're trying to do here.
And like I said, we're all looking to get to the same place. It's picking the road to get there. So we just haven't landed in 10 months time, 11 months time that I've been working on this. We just haven't found the road that we all like, but nobody disagrees on the destination. It's just how do we get there? So we're in Vermont. We don't have a map, but we're trying to figure it out.
I was just gonna offer, I know Eric had to step out to go somewhere else, of coordinating with Eric to see, take your recommended language, and maybe it's even that we have to get on the Zoom or something, and figure it out, like, I feel, yes, we can figure that
I'd
out.
be happy to do that.
Thank you. Any other questions? I guess not.
Thank you for your time.
Thank you. I think